So from bioethics to regulatory frameworks, legal considerations underpin every scientific breakthrough. This panel brings together leading minds at the intersection of law and healthy life extension.
Hello?
Does that work? This panel will be moderated by Tom Zuber, and our panelists will be Carla, Amy, and Jessica. So if you all can join me on stage. All right, here you go. This is the working one, I believe.
Hello, everyone. Good to see some of you again. I'm Tom Zuber. I'm the managing partner of Zuber Lawler. We're a law firm headquartered in Los Angeles. We have attorneys throughout the country. We do work throughout the world for leading Global 1,000 companies, including pharma companies and biomedical device companies, but we're also quite nerdy. We think a lot about the future, where we're going to be in 10 years, and we work backwards for our clients, and that leads us to places like blockchain and cannabis and psychedelics and clean tech and quantum computing and AI and longevity. I have a personal passion for this space, and I think the thing that I'm most excited about in longevity is that as an attorney, when we pick up a new client with a new technology, we get to learn a lot about it. And to me, that is just that process of ever ongoing learning is very exciting. I'd like to introduce my very exciting panel here. I'll start with Carla Pareja, my colleague to my right. Carla, if you could say a few words about yourself and your company. I guess I stole your thunder on that one.
Everything already. My name is Carla Pareja. I'm an associate at Zuber Lawler, and I'm in the transactional department, so I do a lot of M&A and private finance and regulatory work. As Tom mentioned, we do a lot of work in emerging industries and technologies, so I do this type of practice area across many of these industries, including longevity.
Jennifer.
Hi, it's Jess.
Pardon me, Jess.
Hi, I'm Jess. Hi again. I teach at the University of Richmond. I'm a bioethicist, and I wrote a book called Pharmaceutical Freedom about rights of self-medication. And then I guess more in the legal context, I've written about things like scope of practice reform, contracts and liability, and which kinds of agreements should be enforced or not, and then also commercial speech regulations and government censorship in the drug space.
Amy.
Hi, everyone. I am Amy. I am treasurer at A4LI. I don't think I need to introduce my organization to this crowd. I'm also a lawyer and an AI governance professional, and I'll be commenting today from an AI governance perspective.
Thank you, Amy. And a preliminary note, and thank you, Jessica, for joining us. It was a last-minute addition, and Jessica, we're absolutely thrilled to have you here, and thank you for kind of saving the panel because we had a colleague who dropped out at the last minute due to a personal circumstance. So thank you, Jessica, very much for filling in, and thank you, Dylan and Brenda, for making that happen. So let's go ahead and start with a first general question. What are the main legal hurdles facing companies developing longevity products today? And Amy, if you'd like to start on that.
Yeah, sure. So we've all witnessed the explosive growth of AI in recent years. It touches all of us in some really fantastic ways. I'm personally thrilled to see all the advances that a lot of you are making with the use of AI. It's just really transforming the longevity research landscape, so that's fantastic. But as exciting as this wonderful AI terrain is to traverse, the landscape overall from a legal and regulatory perspective is rocky. It is complex, it is uncertain, and it's ambiguous in a lot of ways. And we can kind of see some of this play out with AI incident trackers. There's multiple institutions setting up these incident trackers. There's one tracker that reported that there were 375 reported AI incidents in 2024. And so all this to say, now is a really good time to put into place an AI governance program. It will not only reduce the risk that you become victim and are added to the incident tracker, but also it will help you to navigate the regulatory uncertainty that exists today. And I'll just briefly run through the three main ways that there is regulatory uncertainty. So first of all, it is a patchwork of regulation and legislations worldwide. Different countries and states are regulating AI in different ways. In the US, at the federal level, there is no comprehensive federal AI-specific legislation. But there are over 200 proposed AI laws at the federal level, and at the state level, over 300. As for existing laws, some states like California have AI-specific laws, Utah, Colorado, but then there are a ton of states that don't. So there's, it's a patchwork there. As at the FDA level, the FDA has issued some discussion papers and draft guidelines on the use of AI in drug development, for example, but there's nothing concrete right now. There are no finalized guidelines, so this field in particular, you're gonna have to stay on top of that. And then finally, the EU AI Act. I think probably many of you have heard of this and are aware of it. It is the world's first comprehensive AI legislation. It was passed in the EU last year. And that's what's great about that, is that that's certain. It actually exists, which is great. It's also certain that it's extraterritorial in scope. So you should be thinking about whether it applies to you. But it's also uncertain in some ways. So for example, we don't know the scope of the AI Act and how it applies to AI in drug development and manufacturing. In addition to that, this crowd might be interested to know that an AI tool used for scientific research is exempt from the scope of the Act, which is good, but the Act doesn't define scientific research. So there's ambiguity there. And as a longevity enthusiast, I am really keen to see you all succeed in your use of AI. But as a lawyer and an AI governance professional, success means not just leveraging the technology effectively, but ensuring that you stay ahead of the legal and regulatory curve. And you might be saying, well, how do I stay on top of the legal and regulatory curve if we don't even know the scope of the regulations and we don't even know what regulations are going to exist in the future? And so this is where I feel AI governance can really play a great role. It can really work with you and reduce risk at every step of the way as you use, deploy, and develop your AI tool. Small decisions now could come back and bite you in the future, and you don't want that. And another thing to keep in mind is that there is business value in having a governance program. It will give you a competitive edge. Maybe some of the investors in the audience feel the same way, but it will build trust with investors because they will know that you're committed to mitigating your risk, and that you're committed to staying on top of the evolving regulatory landscape. So, focusing on AI governance now will reduce your legal debt, your reputational debt, and your technological debt.
Thank you, Amy. Go ahead, Carla.
So from my perspective, the main legal hurdles in the longevity industry go around managing innovation with privacy, regulatory, and ethical concerns. Right now, the regulatory framework is not up to speed as to where the longevity industry is, and that happens typically with emerging industries and technologies where the rule books go much slower than the technology or the science in this instance. And this presents a number of issues. For example, right now we have a disease-focused system, right, in the longevity space. And I don't think it's only in the longevity space, but also in the health space. I have a personal example, actually, of something that happened. When you go to the doctor, typically, a lot of doctors are very quick to prescribe medicine as opposed to looking at the underlying reasons of whatever health issue you're experiencing. My mom, about 8 years ago, she's a type 2 diabetic, and she went to the endocrinologist, and her endocrinologist told her that soon she was going to have to start injecting insulin. And she shared this with me, and I told her, has the endocrinologist looked at what type of diet you're having, supplements, other more natural ways of trying to delay or hopefully prevent you having to inject insulin? And she said no. And that was very surprising to me. So I put her in touch with a functional nutritionist that I like a lot and respect a lot. And through diet, through some changes in her diet, supplements, she still today has not had to inject insulin. And the endocrinologist actually removed 2 or 3 of the pills that she was taking for her diabetes and for her cholesterol. Another example that actually we were discussing at lunch, and I thought it was relevant to the panel, is I read that there was a clinical study in the Netherlands of kids with ADHD. When a kid is diagnosed with ADHD, generally doctors prescribe medication, right? So on this clinical trial, there were 70 kids diagnosed with ADHD, They remove gluten, lactose, dyes, sugar, and screen exposure for 3 weeks, and 70% of these kids stop presenting symptoms of ADHD. So that's pretty compelling and pretty incredible. And the fact that we have this disease-focused system presents a number of issues for the longevity industry. For example, the FDA and EMA focus on a one disease, one drug system. And for longevity interventions, that's hard because they focus on the mechanics of aging, right? The FDA requires that a drug affects how a patient feels, functions, and survives. And for longevity interventions that are preventive in nature, that's also another challenge. And similarly with surrogate endpoints, hard points on clinical trials for longevity are very expensive and very long, and there is very limited surrogate endpoint acceptance. So from the regulatory perspective, these are the issues that I see. From a privacy perspective, longevity products or longevity solutions collect extremely sensitive personal information. Think about 23andMe. So they collect your DNA, and not only they provide information about potential diseases, but they also provide information about your family members and future generations. Or the Oura Ring, which I want to buy one soon, but the Oura Ring over time builds a very specific and detailed health profile. And the more long-term and specific the health data is, the more valuable but vulnerable it is at the same time. Vulnerable to, for example, data breaches, vulnerable to discrimination. Imagine that one of these products show that your biological age is higher than your chronological age. Would insurance companies be able to use this information, for example, to increase your premiums? And there is also the data sharing and repurposing. A lot of times when we provide our personal information to some of these companies, we think we're providing it for a certain purpose, but a lot of times this data is repurposed. And even if there are opt-in mechanisms, a lot of us click, and we don't even know what we are clicking and accepting. To wrap up from an ethical perspective, if longevity solutions are only accessible to the wealthy, we are deepening the health inequalities that currently exist already. So this is my perspective on the legal hurdles.
Thank you, Carla. Jessica, let's start with you on this question, if we could. Are there unique challenges, legal, regulatory, ethical, for interventions that target aging itself, as opposed to, say, a specific disease?
Sure. I think in the previous two responses, we saw where some of those challenges arise from. And part of the challenge happens because of the structure of how investment in this space works, who's investing, and people who want to minimize their risk while also promoting innovation. And there's a trade-off there. So on one hand, you were saying like people don't want to be embarrassed, they don't want to like cause harm, they don't want to get into legal trouble, and so they really want some kind of regulatory framework to give them guidance so that they can cover their butts, so that they can feel assured that they're minimizing risks associated with their research and their investment. On the other hand, those very same guidelines can often be an impediment to innovation, and also, when they're governmental guidelines that are enforced by the government, a restriction on people's freedom of inquiry as researchers, people's medical autonomy as patients and consumers, people's freedom of speech when it comes to advertising potential use cases for their research. And so any kind of legal restriction has a bunch of risks of its own. So because you're risk averse, you say, please, I want a governance structure. We should have some kind of regulatory framework. Not seeing that that regulatory framework is also risky in a bunch of other ways, and nobody sees the people who are harmed by the risks associated with excessive regulation and how we know it slows down regulation. Every time there's a deregulatory intervention in these types of spaces, those spaces become more innovative as a result of the deregulation. And so there's a risk on both ends, but people who are risk averse have a psychological need to put the risk off on someone else and say, I'll let the government handle it, or I'll let someone else handle it, and then if I can check all of their boxes, then I'm good with God. instead of taking responsibility for their own research and thinking for themselves and letting patients make decisions about their own bodies in that way as well. Now, so my beef with this is that I don't think any of that should be governmental. If people want to invest in private certificatory agencies, I think that's a great idea. And I think that's a really underdeveloped space within biotech of having kinds of private certification risk management services for people that are non-coercive and non-governmental. But don't act like it's like, oh, we're so innovative, we're so at the forefront, we care about medical freedom, if you're also simultaneously calling for more regulation. Moreover, a lot of the cause for more governance and more regulation in these more innovative spaces is coming from large-scale institutional actors, not because they actually care about safety, but because they care about market share. And like smaller, innovative, new companies are a threat to their market share. And so if you see really big names and successful companies in the space calling for more regulation, you should be suspicious because that makes it easier for them to just buy you up instead of having to actually compete. It's an anti-competitive, innovative policy. And so I'm just reluctant about these calls for like a more of a governance structure because I think that it's detrimental to innovation and violates people's rights.
Wonderful, and I agree with you. I think that oftentimes is the incentive there in over-regulation when it does occur from the top down in terms of the economy. Yeah. One other thing I'd like to point out in regard to age-related treatments as opposed to disease-specific treatments. One of the things about this industry that makes it challenging and exciting is that we're dealing with aging. How do you prove the efficacy of a drug, for instance, that treats aging? You need, ultimately, at the FDA level, and if we have time, we'll get to this, you're going to need a stage 3 clinical trial that's going to deal with a larger human population. Do you wait for them to die in order to, and how big does that population have to be to prove the efficacy of an age-related treatment? As opposed to treating a specific disease, where if you're treating cancer and there's a remission, you can assess that in months or certainly years. And that's a very big difference here. So there's a lot of excitement in this industry, but also it does present its own unique challenges, and some of those challenges are legal, and we can talk about that today. I think that that's a segue into our next topic area, which is intellectual property, a personal passion of our law firm and of myself personally. One of the things about law that kind of disturbs me is it's often looked at as a reactionary expense item. And I think particularly in the context of emerging industries like longevity, that's really the wrong way to look at it. And that's a strong statement, but I really believe that. I think that the law really is a means of acquiring competitive advantage. I'll say that again. I think that the law is a means of acquiring competitive advantage. And you invest in legal compliance, you invest in IP, you invest in FDA regulatory compliance and regulatory approval pathways for the sake of acquiring that competitive advantage. And that's such an important aspect of this conversation. It's such an important aspect of entrepreneurialism, and it often gets lost. So I think that intellectual property is a good place to sort of make that point. And on that, I think I'll start with Amy, if that's okay. Amy, what are the advice that you'd give startups, we have startups in the room here, to navigate, trying to navigate the patent landscape?
Yeah, so first of all, I just wanted to clarify in response to your comment. When I talk about AI governance, I'm not talking about governance at the regulatory governmental level. I'm talking more at the company level. And the point is not to over-regulate your activities and deter innovation. It's more to ensure you don't get into trouble, basically. That's what I care about as an AI governance professional. So I just want to make that clarification. And
In trouble with who?
in trouble with regulatory authorities,
Yeah.
in trouble with other vendors, you want to avoid litigation, things like that. So AI creates some amazing inventions, drug compounds, research outputs, a lot of great stuff. But the IP laws have not caught up. The IP landscape is changing. Patent laws that traditionally apply to inventions made without the use of AI might no longer apply to inventions made with the use of AI. And so you should be thinking about the implications for you and whether you own your own inventions. Let's just say you're a drug development platform and you have a Gen AI tool that you want to use to generate a drug compound, and it does. In the EU and the US, patents that are created solely by an AI tool are not patentable. Most patents or inventions fall within a hybrid category. where the invention is created by both a human and a tool. The US Patent Office has provided guidance that that is patentable, provided a human has provided significant contribution. Well, that's great that they've given us some great guidance that, okay, you have to have a human that provides significant contribution, but they didn't define significant contribution. So there's uncertainty there, and so we'll just have to see how that plays out. It'll be decided on a case-by-case basis. And again, that's where I feel AI governance at the company level can really help, because it will help you track inventorship and also document through your use, your training, your deployment of your AI tool, all the ways that humans have made meaningful input into the invention. And that can, in turn, help reduce the risk of outright patent rejection and reduce the risk of patent litigation down the road where your patent might be invalidated.
Thank you very much, Amy. And I'm going to step in a little bit to offer some commentary, given that we had a last-minute switch here, and some of this was going to be handled by our colleague who's not here. Can I ask a question to the room here? How many of you are pursuing any sort of patent protection, that you have a patent or you're pursuing a patent application? Okay, good. That's a pretty sizable number here. I would have expected it, by the way, to be a bit larger, because it is such an important part, I think, of this industry, the technology aspect of it and who owns what. I think one of the places to start with patent law is making an admission as the managing partner of a law firm that does an awful lot of patent work and technology work. Patents are outdated. And it's a great, I think, contrast to a longevity industry that's so forward-looking. We're nascent. We're before the inflection point, as mentioned and emphasized on a panel I was on earlier today. And at the same time, patent law was made for Alexander Graham Bell inventing the telephone. And if he didn't do that when he did it, we could have been shouting out our window for another few decades. Or when the light bulb was invented, if that wasn't invented when it was invented, we could have been reading by candlelight for another set of decades here. Whereas today, technology turns over so fast. It turns over between every year or two now, and that'll reduce to 6 months, and it'll reduce further, particularly with AI and quantum computing as these tools come into place. And at the same time, patent law really hasn't changed all that much. You get a monopoly from 20 years from the date of filing. I don't want to speak so much, because I'm not that ambitious, to try and speak to the rightness or wrongness of patent law. What I am saying is that it exists. And the fact is, if you show up in a forest and you cut down the tree first, you own the land. And that's really how to look at patent law. So in the context of this industry, where there is so much innovation happening, so much technology happening, you can't not look at patents in most circumstances. In some circumstances you can. You're making a market play, you're a first-to-market play, or you've got some other competitive advantage. But otherwise, it really should be, in consideration at least, the notion of making some reasonable investment in patents. And when you take a look at the most valuable companies in the world, oftentimes they're backed by patents. Just like the US government is backed by gold, these companies are backed by patents. And so that I think it behooves us to take a look at patents and to wonder whether or not it's worth investing in something called an IP portfolio, or patent portfolio, and to look at it systematically in those regards. On that note, one of the other aspects of patents is that they're also, in addition to looking at it in terms of offensive, I'll say from an offensive perspective, there's also a defensive component to it. It would be a terrible thing to invest in a company and to invest years or even decades of effort into a company, pursuing, for instance, FDA approval or something else, and to find out buried somewhere there's a little patent somewhere that precludes your business model. So it makes sense also to have some reasonable understanding of the patent landscape out there so that you can navigate it better. And it gets back to the point that the law is not just an expense item, and ideally it shouldn't be. It should be a proactive investment opportunity, and you're investing in the opportunity to acquire competitive advantage over some of the competitors in the space. So that's obviously a topic we could speak a lot more about, and this is a shorter panel, so I'll stop there. But what I think the general point here is, do take a look at IP, do take a look at patents. The fact is that it's an outdated system, but this outdated system exists, and if you show up in the forest and you chop down the trees first, you own the land. And that is a very powerful sentiment to keep in mind. Let's go ahead and pardon me again, I'm sort of stepping in here as a speaker / moderator in light of the last minute change. Let's move to data privacy and health information. Longevity research often collects, and we talked about this a bit earlier, collects sensitive personal and genomic data, what are the key privacy concerns? And we'll go ahead and start. Jessica, if we could start with you.
So privacy rights are so tricky. And somebody mentioned before, you know, if you agree to the terms of service on Apple, you're like, yeah, sure, track me, whatever. And people click through, and they don't necessarily really investigate how their data is going to be used or how privacy rights work. Boilerplate is like very morally controversial, whether or not we actually can count people consenting to these boilerplate privacy disclosures and notifications as giving meaningful consent. However, at some point, we should also consider that it is in some sense paternalistic to assume that everybody has the most risk-averse views of privacy that they possibly could. And so even though we all think like, oh yeah, I like clicked, like I consent to terms and conditions or whatever, that's not necessarily the most meaningful form of consent when it comes to how your data is used. There's also a cost to patients or consumers becoming educated. There's a time cost, there's a cost associated with whether the product will even be accessible, and then there's a cost of missing out on whatever socially beneficial uses that data could be used for anyhow. And you have to factor that in on the other side. So here again, I think a lot of people who are commentators on privacy are very focused on the downside risks of data breaches or people's privacy being violated or something. But if you talk to patient advocates who have lived with HIPAA through the past 30 years, they will say that privacy protections, which are ostensibly for their benefit, have been an impediment to quality care. And so we should take the lesson from HIPAA and how it's like completely screwed up everybody's patient experience. I know that you probably have like 5 different patient portals with 6 different logins for 3 different providers that you have to kind of coordinate for your own care. Take that lesson to say that it is not free to be a little bit more cautious when it comes to privacy regulation. And we've learned that because think of how many life years people have spent literally just trying to access their own medical data through HIPAA. Another thing that's important is a lot of steaming regulations on what kind of data is accessible to people, what kind of data they can consent to give to a company, and what kind of company they can share back, are regulations that restrict people learning information about their own bodies. And so if you have rights of informed consent in a clinical context, in order for you to give meaningful informed consent, you have to have access to all relevant information. And that includes all the information that you would take to be relevant for you. But because of some kinds of privacy regulations, patients are themselves shielded from accessing relevant information about, for example, their risk profile or correlations or demographic similarities between them and other kinds of patients who have similar kinds of conditions. And those types of forms of government censorship on truthful speech about a person's own body, first of all, I think are unconstitutional, but they also make it so that people can't give really meaningful informed consent. And so there's a real cost to looking at this new space and thinking, oh, we need to have stronger protections for genetic privacy because we've already erred so long for decades when it came to medical privacy. And I don't want to just double down on those costs.
It's the most depressing job because I drive those and nobody reads them. Like nobody reads them. I think I'm one of the only ones that reads it, the same as like the liability waivers. I read them and my friends are like, what are you reading? So I guess that's being a lawyer, but nobody reads them. So nobody knows what they are agreeing to.
So let's, on that note, Carla, let's stay with you, given your focus on the subject matter. How can companies ensure compliance with regulations, and I mean specific regulations like HIPAA, as an example, particularly in the longevity space?
I think longevity companies cannot take a check-the-box approach to privacy. They have to embed privacy into the core of their operations, and that means starting early, like with IP, with a data mapping. What type of data are you collecting? What laws apply to you? How are you handling the data? How long are you handling for? How are you responding to users' requests? And for HIPAA, for example, that means potentially having business associate agreement, having a good internal privacy policy and handbook in place, training staff, because most of the time the staff are the ones that are dealing with the data, training them regularly and helping them understand what obligations the company has, and also strong vendor oversight, because even if you're doing the right things in your company, how your vendors are treating the personal information that you're sharing with them can get you in trouble too. With the GDPR, for example, that means sometimes getting data processing agreements and this type of heavy oversight on vendors.
And for those of you who don't know what the GDPR is, it's the European privacy regulation body. On that note, Carla, as someone who's barred in both Spain and Europe and the US, one of the challenges, of course, with privacy is it's so disparate around the world. It varies by jurisdiction. There are so many jurisdictions, and there are some jurisdictions that really take it more seriously than others, Europe being one of them, California being another. Can you speak to that? How does a company that's a smaller company, how does it meet that challenge of managing such a large body of regulations that varies by jurisdiction so fully as privacy law does?
I mean, it all depends on budget, right? And if it's an early stage company, budget is generally an issue to comply with every single law across the United States, the state laws, or around the world, which is even more challenging. So what some companies do is start by complying with the most restrictive privacy laws, like the GDPR or like the CCPA, and then building from there. As more funds are available, potentially complying with other jurisdictions. If you're complying with these more stringent privacy laws, you are in a pretty good place. And one of the things, of course, to start with is understanding which laws apply to you, because a lot of US companies say, oh, I'm in the US, the GDPR doesn't apply to me. But nowadays with the internet, it does apply to you, probably if your website is accessible to Europeans and you're collecting data of Europeans, or you're marketing your services in Europe, even if you don't have direct revenues. So this is something that, and same with the CCPA, by the way, there are some like revenue thresholds and things like this, but a lot of times it's very easy for the CCPA apply to you, and when you don't realize it, a lot of clients say, oh, it doesn't apply to me yet, but then next day, because your volume of personal information that you're collecting suddenly gets to the threshold of the CCPA, or your revenues get there, no one is going to remember and say, actually, let's look daily where our revenues are, how many users are we collecting personal information from. So tomorrow, is the day that the CCPA starts applying to me. People don't think this way, so a lot of times what we recommend, if there is a reasonable thought that at some point in the near future the CCPA will apply, might as well comply with it now. It's not that complicated to prepare a California notice when you already have like a privacy policy in place.
Thank you. We just have a few minutes left here. I want to hopefully leave time for a question or two at the end. So if we could take 30 seconds apiece, it'd be great to hear from everybody as they're inspired. What best practices should innovators, should companies in this room adopt in order to avoid legal pitfalls later on? And we could start with anybody on the panel.
I'll start. So I think I've established that I am the AI governance evangelist. But in all seriousness, I really do think AI governance should be not an afterthought or something we tack on at the end. It really should be a core part of how we build, how we innovate, and how we protect our companies and ultimately people who are at the heart of longevity research. And I'm not suggesting that you rush out and put an AI governance program in place within 3 months. But even baby steps, little steps now, will really pay dividends in the end and reduce risk. For smaller companies, just quickly to say, if you focus on AI governance now, it's going to be much easier to scale later as your company grows and regulations evolve. And so in a field, just one more thing I just want to say, I attended an AI and privacy conference last week here in DC. Sam Altman dialed in via Zoom and spoke at one of the sessions, and one of the things he said was the AI world is very dynamic, and companies really need to be agile and be able to handle the upcoming challenges that arise. And so I'm really hoping, in my view, an AI governance program can really help you with that by scenario planning and helping you to prepare for unforeseen challenges.
Questions or no? Do we have time, Dylan? No? Okay, Dylan's telling me to get off the stage, and he's giving me... Yeah, that...
We can answer them after.
All right. Well, we got one question, Ron. It sounds like, and you get to ask it. Yeah, Ron, if you could start with your full name and the name of your company, and that would be great for the audience's sake.
So my name is Ron Primus. I'm a physician in Manhattan. Question I have, it's a little off topic. What are the legal implications of physicians that provide medications off-label, like metformin, which hasn't been approved for longevity, or rapamycin, which hasn't been approved for longevity? Like, I'll have my
Yeah.
patients sign like a waiver, but I don't know if that waiver is going to stand up in court. So just quick question.
Well, off-label prescribing is legal, like you're allowed to, and FDA, when asked about off-label prescribing, will always run out this line where they're like, we do not regulate the practice of medicine. The thing that's the issue is off-label marketing or any kind of off-label advertising. And if you do off-label marketing or advertising, the Department of Justice can come after you. And currently there's a split in the circuits, and there's a lot of unclarity, I think, about the constitutionality of off-label marketing restrictions, because it's a content-based restriction on lawful speech that advocates for lawful conduct, or on permissible speech that advocates for lawful conduct. So like, seemingly they shouldn't be allowed to be censoring that kind of marketing, and yet people, providers, people who work for drug companies, they've gotten in trouble for off-label marketing. Now, you know, to your point of like, how do I minimize my legal risk? I get it. Like, people have to minimize their legal risk, so like, watch out about like the letter of anything that you say and anything that could ever be constituted as a marketing document, or anything writing, or any speech that's paid for by any kind of manufacturer. But also, I do think that people who are in these spaces as providers and like people who manufacture things should not only invest in your law firm services and legal aid, but should also invest in policy reform to change these policies, which are already so restrictive, because you can just be playing defense all the time against an unfair policy regime. But the thing that's really important for promoting innovation and effective patient care is changing the policies for everybody. And so instead of just watching out and complying with what I think is unconstitutional state censorship, people should also advocate for changing those policies.
Great penultimate point. The ultimate point is that there was no legal advice offered on this panel, and there's no attorney-client privilege between us and anyone in this room. Thank you, Dylan. Thank you, Brenda. Thank you, A4LI. And thank you, panelists.